this is John Morris, COO of Forever North Partners, again with Jeremy Sanders, our Chief Legal Officer. And I wanted to be able to continue on our discussion regarding patents and those types of things.
Each country has its own patent office and its own patent rules. There's quite a bit of harmonization around the world, at least today. As somebody typically will file a patent in the United States first, there's then a 12-month grace period in which to file any foreign patents. And in order to enforce a patent in another country, somebody must own a patent in that country. And that's done by filing the patent application, prosecuting it, making sure that that patent application is novel and non-obvious in view of other known art that's out there. And then each foreign country, their own patent office will grant that property right to the patent holder. There are a lot of efficiencies in place, a lot of treaties and cooperations that allow a patent filer to file much more efficiently than having to file in 180 countries individually.
Yeah, I was going to say that would be a little laborious.
It can be. So, for example, there's a patent cooperation treaty that most of the countries of the world have signed up for. And that allows a patentee to file a single application in English with this patent cooperation treaty with one of the receiving offices around the world. And that can then go through kind of a fairly expedited prosecution where a patent examiner will look for prior art that might disclose identical or very similar technology. And that process can happen before the patentee decides which countries to specifically enter. And if a lot of the formalities are taken care of at this patent cooperation treaty stage, it can be fairly efficient to then go into each country and get a patent to issue in each one of those countries.